Now, rental bidding, landlords and or agents will not be allowed to have what is being called rental bidding. So if you market your property at £1,000, 10 tenants go and do a viewing, what we'd normally do is say, all put in an offer. Some tenants will offer more to try and secure the property, particularly in COVID times, rents were being offered way above what we were marketing for. That will be illegal. If you market at 1,000, you cannot accept a penny over 1,000. You can accept under, of course, but you can't accept anything above that amount. So remember what I said to you earlier, this is why I think what landlords will do is push the market. I think if you think your house is worth £1,000, you'll probably try it at 1,100, see how you go. If you don't get it, you'll drop it. And that's how the rents will be pushed up. And if they need to drop it, they will. Particularly if you've got a tenant in situ and you've got your 2 months notice and you've got 2 months to test the market, haven't you really? If you're getting viewings at 1,100, the likelihood is it's worth 1,100 and you'll get 1,100. If you're not getting viewings at 1,100, the likelihood is it's overpriced. So I think this will push up the rent. You cannot encourage or accept a higher rent than the advertised price. And for this, there's some quite hefty fines. The magic number 7, so it's £7,000 fine for one offence, £7,000 fine for repeat offences. So effectively, if a landlord is fined once, you are fined £7,000 for accepting higher than the rental market. 1 year later, you're fined again. You will be fined another £7,000 for the repeat offence, plus £7,000 for the offence. Effectively, that's 21 grand you'll be fined, or can be fined up to. So we have to be really careful that we're not breaching these laws, because the £7,000 is for the individual fine, the next year for the individual fine, but plus £7,000 because you've done it more than once. So there's going to be local authorities, and they're going to be all over Rightmove and all of the property portals watching what you lot are doing. When they've seen that you've served a Section 8 through the courts to evict a tenant, they're going to be watching Rightmove to see if you put it up for sale, and more importantly, if you put it back up for rent, because that's what they're looking at. That's what will cause you the prosecution. And also remember that tenants can apply for rent repayment orders. And also, with this particular part of the legislation, when the property ombudsman is in place for landlords, they can also take you to property ombudsman. That will be their other route to redress. Now, the property ombudsman is only a legal requirement for us as letting agents at the moment, but the property ombudsman can award an amount up to £30,000 to a landlord or tenant against an agent without the need to go to court. So when you all have to be part of the property ombudsman, they can take you to court if you have done it. So there'll be financial benefit for tenants. So that's how it's going to be policed. I do think it's really important just to cover the rent repayment order very quickly. Rent repayment orders in the new world on the 1st of May 2026 will be up to a maximum of 24 months rent. So the amount that I talked to you about that's currently here, 12 months rent, will become 24 months rent. So it's doubling. So remember what I said to you earlier, that tenant that can apply for 12 grand would now be able to apply for 24. And the period of time that a tenant has to apply for a rent repayment order after the offence has been committed has been extended from 12 months to 24. So they've got double the time to pursue you and double the amount to gain. And there are multiple new reasons that tenants can make a request for a repayment order. And it is all surrounding documentation, evidence, proof, and so forth. This, I think, will be the fundamental one thing that drives enforcement in our sector. Why? Because the cash is straight in the tenant's pocket. So we need to be very, very mindful of that. The most common reason rent repayment orders are taking place at the moment are exactly the reason I said to you earlier. A property requires a licence and the landlord doesn't have one. Because unfortunately in the private rented sector, a lot of landlords that aren't as educated as we are, because it's our job, think that licences only apply to HMOs, but they don't. There's so many areas across the UK now that fall under selective licensing. And when an area is selectively licensed, it includes every single property in that area, not just 3 or more people. It could mean a studio flat, a 1-bed flat. It's irrelevant. If it's in that area and your property applies, you have to have a licence. Another example, we have a branch in Liverpool, and in Liverpool there are 3 boroughs of council that have enforced selective licensing: Sefton, Liverpool and Wirral. All 3 of them. So that's pretty much the whole of the area that we cover falls under selective licensing one way or another. And every landlord that falls into those categories has to have a licence. And that's why when I told you about my colleague's daughter, Liverpool city centre, no licence, rent repayment order can be put in. But the amount is doubling. And there's a lot more reasons why people can apply.